Hello there, everyone, and welcome back to Goyette, Ruano, Thompson. My name is Paul Goyette, and I'm the founder and president of Goyette, Ruano, Thompson, a California headquartered law firm, full-service law firm with offices throughout the state of California, and we do work in a number of other states and federal jurisdictions as well. So what I'm talking about today is going to be an extended topic on bulletproofing your corporation. How to make your corporation as secure, as bulletproof as possible to the extent you can. And you can, there's many things we can do, and we're going to talk about those right now. Now, bear in mind, why do you set up a corporation? Remember, a corporation, whether it be a C corporation with shareholders, an LLC with members, even, a partnership, for example, which is a formal structure, those are all separate legal entities recognized by the law to be separate entities with their own rights and responsibilities, duties, and obligations. Just for your reference, in California, there's a California Corporations Code, which governs almost all corporate governance. Every state has a corporations code, and they vary substantially. California, as you might expect, is one of the most regulated. Many other states aren't nearly as regulated. Now, federal laws involved typically deal with publicly traded corporations. So the SEC, for example, and so forth, that's all in the federal realm. And then taxation is primarily a federal concept under the Internal Revenue Service, but many states have corporate taxation as well. California, like everything else in California, tax is big. Okay, so the whole idea behind setting up a corporate entity is to protect your personal assets and to create this entity that has a life of its own that operates the business. So in any business, certainty is what is most important. To the extent you can predict the future, you can predict your growth strategies and your profitability. So what you try to do with corporations is set them up in such a way and operate them and govern them in such a way as the future will be predictable. Now, what's the risk if you don't adequately follow some of the tips I'm going to give you today? Well, the biggest risk is you could be personally liable. So if you incur significant debts or if you have large lawsuits against your company, which are unavoidable in today's society, if they're able to do something called piercing the corporate veil, that would be the plaintiff in those cases or the taxing authority, for example, can pierce the corporate veil. And that means they get through the corporation and get to your personal assets, where they get to your personal savings, your personal investments, your personal home possibly. And there's a whole nother series I do on asset protection, which you're going to maybe want to tune into later. But today we're focusing on the corporation and how to operate and run your corporation as effectively as possible to avoid any problems so you can protect your personal assets. So the first thing is choosing the right business structure. You've heard all the different corporation types that are out there. Probably there's a lot of misinformation about them. They're all effectively their own separate standalone business entity. The major corporations that we set up are corporations with shareholders, typically C corporations, and then there's LLCs, limited liability companies or limited liability corporations. Corporations themselves have shareholders, LLCs have members. Corporations have bylaws, LLCs have operating agreements. Both documents are the functional rules of the road, the rules of the company, how the company is supposed to operate. Frequently, those documents are written, they should be written pursuant to the rules, regulations, and laws in that state where you operate. Now, there's a couple things to think about. It's not just where your company operates, it's where's your company set up. So we set up a lot of companies for clients where we might set up the corporation in Wyoming, for example, which is very favorable, very easy. We love it there in terms of setting up your corporate structure. But you may be operating in many other states. So you're going to have to follow the corporate rules in the state you're operating, as well as be aware of the rules in the state where you've incorporated. Probably historically, the most common state to incorporate in was Delaware. That's changing for sure. But there'll be Delaware corporations that operate maybe in every state in the country and oftentimes internationally. So the first question is choosing the right corporate structure. And really that's going to depend a lot on the nature of your business. Do you have employees? Is it a holding company that's just holding real estate? You may want to tend toward an LLC. Is it going to have numerous employees with a lot of operations? You probably tend to go with a corporation. There's another way to do things, and that's by the use of holding companies, which are very common. So for example, you could set up a holding company, which is frequently an LLC. So a holding company may be set up in the state of Wyoming, for example. That holding company would then be a shareholder, possibly the sole shareholder, or a member, possibly the sole member of the operations company under it. So, for example, you have a holding company at the top, and beneath it, you could have one or more subsidiary companies that are either corporations or LLCs or even partnerships that will show up as the holding company being that shareholder or member. Certain states have really good confidentiality rules as well, where it'll be very difficult for a creditor who's trying to collect on a debt or lawyers that are pursuing a lawsuit to find out actually who the principals are of the holding company itself. So that's something to consider. So which corporation you choose is going to be a function usually of what type of business you're involved in and what your goals are with that corporation. But there are some things, regardless of the type of corporate structure you set up, that you need to do. First of all, one of the number one pitfalls to avoid, and one of the quickest ways to undermine the integrity of the corporate structure, is to co-mingle your company and your personal assets. So when you set up the corporation, regardless of the type of corporation that you set up, it needs to have its own banking system. Checking account, savings account, operations account, what have you. You need to set that up separately, and you cannot commingle your personal funds with the company funds. More commonly, and less sophisticated business owners, they will use that corporation as their personal ATM. They need personal money for something, they take it out of the company. They need to buy a personal asset, they'll take it out of the company. And that muddies the water so much and undermines the corporate integrity so much that you're asking for the corporate veil to be pierced. So that's my number one recommendation, is to absolutely avoid commingling personal and corporate monies. The next thing you have to do for a corporation, because remember, it's a separate business entity, you need to file annual tax returns. That's extremely important. You also need to file statement of information or another annual report in the state where you're incorporated that describes who the owners of that company are. It usually describes the directors, the president, the vice president, and so forth. That has to be done on an annual basis. Now, back to filing the tax returns. I recommend you hire a competent, the more competent the better, obviously. You hire a competent CPA to prepare your tax returns. And there's a couple of reasons for that. One, the tax return should get filed on time and done correctly, but also you have a separate set of eyes on your books. So in a more sophisticated company, what you would do is you would have bookkeepers, say, in-house. You might even have a finance director or CFO in-house, and on a monthly basis, they would send your books, all your accounts receivable, all your expenditures, to a CPA or another firm that would independently evaluate that and conduct essentially what's an ongoing audit. That way you catch any problems that might be going on. You'll always catch any hanky-panky like embezzlements and so forth that are going on. And then that CPA will be all teed up to be able to file your tax returns on a timely basis. The next big thing I recommend is you need to follow the corporate formalities as it relates to your corporate documents. If you're a corporation, that would be the bylaws. If you're an LLC, that would be the operating agreement. You need to follow what those rules say. You need to hold regular meetings. They don't have to be every month necessarily, but oftentimes they are. But when you hold a meeting among the members or the shareholders, you need to take minutes and record those minutes. And they can be in summary form. That's fine too. Those minutes get recorded in the corporate binder. So you have a record that you meet regularly, whether that's annually, that could be quarterly, that could be once a month, that could even be more frequently, but that you record minutes of the operations that are taken. When any big corporate decisions are made, too, you should pass a resolution. So you might have the shareholders all voting in accordance with what the bylaws say, how that voting is supposed to go down. Any important decisions that are made with your company, the big ticket items I call them, you're going to want to draft and prepare a corporate resolution. And many companies don't do this on a regular basis, but all the corporate resolution does, it describes specifically what the decision is being made. And oftentimes that centers on big money-related decisions. Or if you have investors in the company and so forth, you may want to do, in fact, I'd highly recommend you do corporate resolutions that describe what's at issue, who's present, what the analysis was, and what the decision is. So the corporation resolves to do the following, A, B, C, D, 1, 2, 3. That way you're going to have a very clear record of what was discussed, what was voted on, and then that corporate resolution, of course, gets distributed to all the officers and directors, but it also goes in the corporate binder. Now, remember, when you're filing taxes for your corporation, it's not just the federal tax return. You're going to have to file a state tax return too. So that's typically done at the same time. There may be a tax consequence for your company as well. And in almost every state, there's a minimum tax you have to pay. In California, for example, it's an $800 tax. Now, there's corporation taxes too for C corporations that you will be responsible for unless you've set your corporation up as an S corporation. And that means you've set up your corporation by making an S election, so all the revenue, all the profits flow through to the shareholders in proportion to their ownership interest of the company. LLCs are always flow-through companies or pass-through companies. So any income you have there is going to come to you and is a personal income. You're going to have to deal with the tax consequences of that on a personal level. You'll still have to pay a very minimal corporate tax, but it's minimal. So for example, my S corporations in California are, I believe, if I'm remembering correctly, they're all S corporations. So any income that's derived from those companies flows to me and I have to deal with it as a personal income tax. That company doesn't pay a corporate tax when you've made an S election. You have to pay a minimum fee in California. Like I said, it's $800. So you need to be cognizant of that. So we can go into a much greater detail on choosing the corporate structure, but in summary, what I usually almost always turns on is the nature of your business. For example, I have many clients, and I do this myself. We have real estate holdings. That real estate holding would be held by an LLC, a limited liability company. That company does nothing more than hold that particular property. On the other hand, if you have a company with employees and operations and a lot of other things going on, that typically it's way more functional to have a corporation where you can operate. And if you have multiple shareholders, and the more shareholders, the more you'd have to trend to a corporation over an LLC. Okay, the next thing I'm going to recommend to you when working on bulletproofing and making your corporation ironclad is choosing the right people to be partners, shareholders, or investors. Now, I'm not talking about employees, although that's very important as well. You know, who you're going to hire in your company. You have to be very careful of that. But what's infinitely more important is who are your partners? Who are the other shareholders in the company? Who are the other decision makers, whether they have a vote? Even if you could outvote them 10-1, who are they? Who are the investors? And this is really important. Who are you letting invest in your company? And are they investing as a pure debt shareholder? Or are they coming in for a piece of equity? Especially if they come in for a piece of equity, you need to know who they are. So the first thing to do is make sure you get to know these people. Do a thorough background check and hire a professional firm if you have to. You're going to need some basic information to do a really comprehensive background check, but that includes, of course, their name and all their contact information, but it also includes their dates of birth, their social security numbers or the like. Social security number is a U.S. concept. There's similar IDs and so forth in other countries, but also get a copy of their passport that has their passport number. Now, with those pieces of information, you can do a very thorough background check and go back decades if you can. Look at, any criminal history they might have. Definitely look through the court systems, and there's all kinds of background check programs out there now that are getting really, really good, where you can see if they've been involved in any lawsuits, have they filed lawsuits, have they declared bankruptcies, and you can get access to those court records. Have they gone through a divorce? There's often a lot of information you can find out there about who this person is and whether you want them as a partner or a shareholder in your company. What's their track record? What have they done before? Have they done anything before? And what value are they bringing to the company? Be sure that when you take on a partner or add another shareholder to your company, that they are bringing value to the company that makes them worth the headache and the costs they will be, for sure. In fact, hopefully they are 10x worth the headache and costs they are going to be. So think about what the value is. The other thing I always recommend to our clients is slow the process down. Don't do anything quickly. Spur of the moment decisions are almost always bad decisions. And be very, very careful what you commit to. Don't throw it out there and commit to something unless you have really, really thought it through. So do background checks, get to know the people you're involved with, assess the value of this person you are bringing into your company. Then in doing so, ask yourself this: are you philosophically aligned with this person from a business perspective? Where are you going with your business? What are you trying to do with your business? It could be a number of different things, and there's no really wrong answer to this, but if you're trying to build your business and trying to scale your business and increase profits, increase market share, and so forth, be sure you have partners and shareholders that are aligned with that vision. For example, you could have partners or shareholders that are 100% aligned with the vision of scaling the company, growing the company, eventually driving bigger growth and bigger profits. On the other hand, you might have a partner that doesn't care so much about that. What they want to do is they want to maximize their take-home and taxable income, which of course naturally detracts from profit margins and might take away from capital you need for scaling and growth. So that's an important thing you need to sort out ahead of time. And backing up, before you make the decision to take on a partner or a shareholder, if anything negative comes up in that background check, kill that deal right then and there. Literally, reject that person as a potential partner or shareholder. Because trust me, if those things come up, they will reoccur, especially as it relates to honesty and integrity issues and as it relates to alignment issues. Also, I've had this experience myself, and many of our clients have. They find out way after the fact that partners they now have in their company are notorious for suing the company as a shareholder derivative lawsuit, leading that disruption, or suing the company or some of its shareholders directly for whatever alleged breach of fiduciary duty or whatever they can come up with. If you find a potential partner, shareholder, investor, or employee is a litigant, has previously litigated cases, run. Do not walk away, run away from them. Finally, the last thing I encourage all my clients to do, and we do this here a lot ourselves, and both in the law firm and my other businesses, is leverage technology. We are in the golden age of exponential technology growth. Use it. Now, it's going to take some work on your part to learn the technology, learn what's out there, get you and your team to adopt the best technologies out there to get the most mileage of every employee you have, and every partner you have, and every shareholder you have. And what it can do for you is minimize the number of people you have around you, minimize the number of partners you have. Use technology to minimize the number of shareholders you might have in a company, and especially use technology to minimize the number of employees you have in the company. If you follow those tips, you'll go a long way to really protecting the strength and integrity of your company and its corporate structure. Okay, the next step that I recommend when you're thinking about maintaining the integrity of your company and bulletproofing your corporate structure is consider your intellectual property. And this is going to vary widely depending on the nature of your business, but all businesses have some form of intellectual property, whether it's trademarks or copyrights, or it could be even patents. And so you need to be aware of what's out there, what do you have, and make sure, first of all, that your intellectual property is protected, that you filed the appropriate trademark, copyright, or patent applications. You probably will need to contract with outside lawyers who are specialists in intellectual property protection to make sure the filings are done correctly. This is very important, that those are done correctly. Now, there's a lot of strategy involved with that too. If you're involved in a startup, if you file an application for, say, trademark protection or patent protection, it is a public act. So if you have competitors out there and you're racing to the finish line on a new technology you're developing, just know that application for intellectual property protection will be available for anyone and everyone to see. So they may know your playbook a little bit about what you're doing. So there's a lot of strategy involved in that. But at some point, you need to protect your intellectual property, whatever it might be, ranging from the name of your company, the trademark of your company, or certainly the patents of any unique process, procedure, or products that you are developing. That's extremely important. And over the long haul, the real value of your company is often tied up in the intellectual property. So it's really, really important to do that. Now, that being said, there has to be very, very clear rules and contracts, if necessary, as to who owns that intellectual property. Does the company own it? If you have, say, a technology company and you have coders working for you in your research and development department and they develop in a particular technology, they may look at this and say, this is my technology. I'm the one who thought this up. This is my property, and while you can use it while I'm working here, but I'm taking it with me. No, negatory. What you need to do is make sure it's very clear with your employees in particular that any intellectual property that's developed in the course of their duties and responsibilities for the company is the property of the company. The same holds true for partners and shareholders who might bring IP or intellectual property to the company. Make sure the rules, the contracts are very clear as to who the owners are. You have to avoid a dispute, because trust me, if some piece of your intellectual property or all that becomes extraordinarily valuable, and it's usually, it might be a year, it might be 10 years down the road, there will be a dispute as to who really owns it. Two more things on intellectual property. As a matter of practice, have confidentiality agreements and trade secrets agreements in your employment contracts with employees, and even in possibly the bylaws or the operating agreement and agreements you have with shareholders and investors. It's important to have those confidentiality or trade secret rules to avoid legal problems after the fact. And then the last thing I would comment on is conduct a regular, preferably at least annual, intellectual property audit. Go over where you are, do an audit of your intellectual property. What have you developed in the last year? Have you filed for intellectual property protections? Of the previous IP protections you have filed for, have they been approved? Have they been rejected? And do you need to deal with those? Maybe file an amended petition and stay on top of that and have an ongoing list where you can keep track of your intellectual property. And then I guess the last thing I would say about intellectual property is, remember, the intellectual property that you have in your company is only as valuable as you are willing to protect it. So let's, for example, say you have a trademark and you believe some competitor out there is infringing upon that. Well, your trademark, even if it's been approved, it doesn't have any value at all if you don't defend it. So what that requires you to do is get your corporate securities or intellectual property lawyer to write a letter to this infringing party and get them to back off, go away, change what they're doing. If they refuse to do that, you have to file suit, and you need to invest money to protect your intellectual property, because if you don't, someone else could hijack and successfully take over from you your intellectual property. So remember, the intellectual property you have in your company is really only as valuable as you are willing to fight to protect it. Okay, now if that isn't enough, there's a whole bunch of other things we have to consider, but if you follow the steps I've already outlined, you're going to go a long way to protecting the integrity of the corporate structure of your company, which, remember, is really, really important to protect all the personal assets you've acquired over the years, either through that company or maybe through all of your other personal business endeavors as well. The next step in protecting your company and its corporate structure is drafting strong contracts. I am amazed at how often sophisticated business people enter into agreements on a handshake. And I know that's the old-fashioned way of doing it, and it all kind of sounds good and feels good until it goes bad, and then it's a disaster. But it is very important that you enter into agreements of any kind, size, or shape with strong, clearly worded, comprehensive contract. This is especially related to your employees. Have some type of employment agreement, even if they're at-will employees, which they almost certainly will be. And being an at-will employee means they can be dismissed for any reason, with or without cause, with or without notice, and they can also leave for any reason. And that's typically the rule you want to have in your company. But you need to have an employment contract with those employees and with your shareholders, and you need to have an investment agreement as well if you have investors in your company. And those contracts need to be solid. They need to be comprehensive. They need to be clear. They need to include confidentiality clauses, as I mentioned a minute ago. They need to include indemnity clauses. So if there's a breach of the confidentiality or the trade secrets, that person is going to have to indemnify the company. And that'll put a financial strain on them. And by that, its very nature will inhibit or stop any hanky-panky that might otherwise have happened. So it's very important you have these contracts. These have to be written by qualified and competent people. If your company is large enough, you'll probably have an in-house counsel that will have a library of contracts that will be constantly getting upgraded, or you'll have outside law firm that you work with that can draft these contracts for you. Do not rely on something you pull off the internet or ChatGPT or LegalZoom or something exclusively. That's a good place to get started. And we use those tools, certainly in all my other companies and my law firm. But there's often nuanced details that get missed that could sink your contract ship, if you will. So enter into strong, understandable contracts and make sure everyone, for example, if you hire an employee, make sure they're given the contract, make sure they're given adequate time to review it. Encourage them to get outside counsel to go over it with them, what it means. And if there's a particularly sensitive provision in the contract, what I like to do is put an initial line next to it, for example, a confidentiality clause or a trade secrets clause. They'll initial that provision in the contract to acknowledge that they've read it and seen it. The other provision that needs to go in your contract is a dispute resolution clause, or oftentimes referred to as an arbitration clause, so that any disputes that come up with an employee, a partner, a shareholder, an investor are resolved through arbitration. Now, why arbitration versus the court system? Well, arbitration is faster. The court systems now, especially in California, in Superior Court, federal court can be even worse, are excruciatingly slow. That whole concept of justice delayed is justice denied, apparently everyone's forgot about that, because it could take you years to get through the course. It could take you a decade to get through the court system, especially if there's appeals involved. So effectively is, in my view, completely non-functional. It's also extraordinarily expensive, which is an inhibitor. And so we like arbitration on everything, where a professional arbitrator will hear your case in relatively short order. And that's not going to happen in the course of a week, but an arbitration could happen in 6 months or less. You could have a binding decision by an arbitrator that resolves that dispute, win, lose, or draw, and everyone moves on, which is really the best thing for business. So there are a number of arbitration and alternative dispute resolution clauses out there that you can get, but those need to be included in your contract. So again, when it comes to contracts, I do two things. First of all, when in doubt, enter into a contract. Don't document your agreement by handshake, text message, email, or smoke signal. Enter into a contract, and enter into a good contract. Get your lawyers or the law firm you work with to draft a contract that is clearly understandable and very enforceable. Okay, thanks, ladies and gentlemen. That's going to conclude effectively my part one of this discussion. We're going to have a detailed white paper posted on our website that you can download if you'd like to read up in much more detail of some of the concepts I'm talking about. And of course, you can always reach out and contact me. I will be back with part two of this presentation to talk about some other very important concepts for protecting your company and your corporate integrity. Those include cybersecurity, which is huge right now, which will affect your IT or tech within your company. We're going to talk about compliance and doing compliance reviews. And this is going to vary a little bit depending on the business that you're involved in and the regulatory agency that is overseeing your business, but do regular compliance reviews and make the necessary changes that you need to make. We're going to talk about a little bit of succession and crisis planning. So you should always have a plan in place to protect your downside, because like it or not, fair or unfair, right or wrong, crises happen. And sometimes founders, owners, shareholders, and key people in the company have health problems, they have personal issues, they have whatever comes up, and they might have to leave on relatively short notice. So you need to have a plan in place, at least a general plan as to how you're going to deal with that when it comes up. And then also I have a number of thoughts on financial management of your company, because this is a really important area that's often overlooked, that if handled correctly can avoid a lot of headaches, a lot of sleepless nights in your company, and avoid liability, which all ties back in to your protecting the integrity of your company. Lastly, I'm going to have some commentary on insurance. I'm a believer in insurance. I don't like paying for it. I typically don't like insurance companies for a lot of reasons that I'll get into, but it is important that you have appropriate and sufficient insurances for the different activities you have going on in your company. Thanks very much. See you soon.